Yes.
May it please my lords, my lady. I said I was going to look at two aspects where we have a different stress from my learned friend Mr McGee. And we looked at the first in relation to paragraph 3, the assumption that ECA is already on site is built into most of the code rights themselves. And then your lordships raised questions with me on paragraph 9, which I said was about new sites where there's land only. And maybe that's why paragraph 9 includes the expression in respect of any land. It just assumes that the operator and the occupier are different people. It just doesn't contemplate the operator in situ. The second aspect where we have a different stress is paragraph 22. My lords, we say paragraph 22 is an important part of the jigsaw. And paragraph 22 is on page 1822. And the question arises about paragraph 22 is, what exactly is it directed to? In particular, what work are the words "as an agreement under part 2 of this code" doing? So if your lordships were to look at paragraph 22, with the greatest of respect to him, on my learned friend Mr McGee's reading, it could have read, without those words, "as an agreement under part 2 of this code," it could just have read, "an agreement imposed by an order under paragraph 20 takes effect for all purposes of this code as an agreement between the operator and the relevant purpose." That would do what he wants. It would bring in the characteristics of a code agreement like paragraphs 16 and 17. Why is it focusing on part 2? And my lords, we say, for the answer, of course, one has to go back to part 2. Because in part 2, which is paragraphs 8 to 14 only, there are just two requirements as regards code agreements. There's the requirement in paragraph 9, and there's the requirement in paragraph 11 for writing. So there's just the two requirements, writing and occupier. Paragraph 22 can't be directed to the requirement as to writing. And the reason why it can't is because the notice under paragraph 20, subsection 2, requires that the code right in a part 4, paragraph 20 notice must be set out in writing. So the code right sought will already, by necessity, be in writing. So paragraph 22 must be directed to paragraph 9. Its purpose, we say, reflects the fact that Parliament is assuming that operators in situ will be making paragraph 20 applications, and that this dispensing power, which, as my Lord Sales pointed out yesterday, this dispensing power, which is effective at the date that the agreement is imposed, the date of the hearing, will therefore be needed so that paragraph 9 does not get in the way. Forgive me, absolutely. Thank you. Apologies. No, it's fine. Thank you very much. So if only operators out of occupation were able to seek code rights under paragraph 20, therefore, because paragraph 9 governed every situation, paragraph 22 would not be necessary. So, my lords, to round off this section, we are adding, with your lordship's permission, 3 things to my learned friend Mr McGee's exposition of the code. Firstly, most of the code rights under paragraph 3 assume the outcome of this appeal that the appellants seek. Secondly, paragraph 9 is limited to a situation where the occupier and operator are different people. It doesn't purport to deal with the situation where they're the same person. And thirdly, paragraph 22 is only necessary to prevent paragraph 9 getting in the way of the imposition of code rights under paragraph 20. It assumes paragraph 20 applications for that purpose. So,
I'm sorry, I just haven't understood the last point. I'm sure it's my fault, but
my Lord,
sounds a very subtle argument, but I haven't followed it.
no, my Lord, we say paragraph 22
Yes.
Has to be directed to paragraph 9.
And what effect does it have on paragraph 9?
It enables the court to to impose code rights, impose code agreements, even when the operator is in occupation.
Yes, I mean, your case is that there is no such hurdle in paragraph 20 itself. An operator in occupation, you say, can operate paragraph 20, and paragraph 22 equates the notice and the order with an agreement under paragraph 9.
Indeed.
Which you say in itself is confined to the circumstance where the operator and occupier are different people.
Indeed, my Lord.
Yes.
Paragraph 20 is just necessary to stop para 9 being a problem.
Yes.
Now, my Lord...
But is the effect of that you can't voluntarily then come to an agreement where the operator is in occupation?
My lady, you can. We say that particular issue can be answered and dealt with on 2 levels. The first level is this, that in a consensual arrangement, by its very nature, the parties are agreeing for a conferral and acceptance of code rights. And it's just not open to them in that consensual situation, because their minds have met in that way, to at the same time be going back on that and saying that the agreement somehow doesn't count because the grantor is not the occupier. So, my lady, if one needs a legal peg for that, one could say it's a sui generis denial of title to go back on for the site provider to say, oh well, I'm not the occupier, or it's in contractual terms you could say it's a breach of the implied warranty of capacity. But those concepts aren't so necessary because it can be described in code language. In code language, the parties, by their consensual agreement, are treating the site provider as the occupier. And my lady's question...
So it's a bit like when you have a preamble in a contract which says we assume that something is the case, even though they know it's not the case, but if they contract on that basis, then they can't go back on that.
Indeed.
So anybody, in fact, can make a contract as long as they're treated as the occupier.
Yes.
It's ridiculous, that argument. So para 9 has no effect at all.
We're saying it's thinking of new site situations. It's thinking of a very simple situation where the operator comes along to the new site. That's why it says in respect of any land, there's only land there. There isn't ECA there. We say it's pretty limited, and that what's gone wrong below, my lord, is that the effect of this paragraph 9 has been allowed to spread throughout the code.
Yes, but paragraph 9, I understand your submission that it's only addressing the circumstance where the occupier and the operator are different people, but on its face it is a very clear provision, and it says that code rights can only be conferred voluntarily in that way.
Indeed, but my lord, we say one has to read the code in the context of the policy and as a whole. And so the answer to my lady's question is also that This is the first level of answer. I have another level, if your lordships don't like this one. The first level answer is the parties, by their very consensuality, are doing what paragraph 22 allows the courts to do more formally. So they are doing their own homemade paragraph 22 by the nature of the consensuality. Now, I said there was another level of answer to my lady's question. It's this. If the agreement is not an agreement under Part 2, this consensual agreement that my lady has posited, if it's not an agreement under Part 2 because of paragraph 9, what is it? Well, it still has, on the face of it, parts 3, 4, 5 and 6 excuse me, applying to it, because we know from paragraph 100 that they cannot be excluded. We may also be able to say that paragraph 11, which is about variations, allows a party to seek variations as long as they're in writing. There's no problem with varying a length of a term because we're talking about code rights, not property rights. Now, there might be a question about the extent to which Part 5 can apply, even though paragraph 100 says it must. And the reason for that is because paragraphs 29(1) and 30 subsection 1a seem to suggest that Part 2 is a portal to Part 5. So the answer to the question is, what then are we dealing with if the agreement's not an agreement under Part 2? We're dealing with an agreement to which part of Part 3 applies, Part 4, possibly not Part 5, and Part 6. But, my lady, if I could then circle round back to our basic proposition, if Part 5 doesn't apply, because it's not a Part 2 agreement, and Part 2 is the portal to Part 5, it makes it even more important that the operator has rights under Part 4, because it's the only way for it to get back into the code. And we know, from the very first point that I made yesterday, that the operator must be able to obtain code rights while in occupation, mid-term, because of words like keep in the definition of the code rights. So, my lady, those are our answers to that question in two different ways. Now, what we come to this court to do is to suggest to your lordships two other routes to reaching the destination that my learned friend suggested was correct. And the first route is what we call the relevant person argument, and the second, which, with your lordship's permission, my learned junior, Mr. Kitson, will follow on in relation to, is based on an idea of the Deputy President of the Upper Tribunal at first instance in Compton Beauchamp, which we say was correct. So it leaves me just to deal with this relevant person point. And the point is this, that relevant person, we say, in paragraph 20, means the person not in occupation next capable of making a competent grant. The person not in occupation next capable of making a competent grant. So it's the reversioner on the occupation, capable of making the grant. The person next up the chain, competent to make the grant. And our best point is a very simple one, which is that paragraph 20 mentions relevant person, not occupier or person bound. It's a deliberate, we say, change of nomenclature. It must mean something different. This is the first time that this concept is introduced in the code. And the switch of wording itself indicates that the application is to be made against a different category of person than just the occupier or person who's bound under paragraph 10. And there's no reference to occupation in paragraph 20 at all, because that isn't the relevant test. Now, my lords, an occupier isn't excluded from being a relevant person, of course, but it doesn't have to be the relevant person. It's not the only person capable of being the relevant person. The competent grantor, in other words, will often be the occupier, especially on a new site, but the relevant person also includes landowners not in occupation, such as where, in particular, the operator is in occupation. Now, in relation to a point of clarification from my Lord Sales, my Lord Sales noticed 20 subsection 1A and B might be alluding respectively to 9 and 10. Indeed, it may. But we say the notion of relevant person is not limited by that. The key matter is that relevant person is a different new concept. And
sorry, just to be clear, you're saying that the relevant person means, it includes the occupier, does it?
yes,
But it also means the person next up the chain from the occupier.
if not the occupier, the person next up the chain
Well, when is it not the occupier? If it includes?
when the operator's in occupation.
Well, that's rather a lot to read into the word relevant person.
Well, my lord,
That isn't there.
well, my lord,
It's the occupier, or if the operator is the occupier, it's the person next under the chain. That's what it means, is it?
well, my lord, no, what we're saying is relevant person is the occupier, or if the operator is the occupier, in which case it can't be the occupier, it has to be the person next up, because who else could it be?
So it's the person next capable of making a competent grant, I think is how you put it.
Yes, it's the person next capable of making a competent grant. So, in the example which my learned friend Mr. McGee mentioned, where the head landlord says no to a code right and the occupying tenant says yes, then the occupying tenant, if it is not allowed to permit it under its lease, will not be the relevant person. The relevant person is the person capable of making the grant, the person permitted to do so.
What I think I'm struggling with a little bit on this point is it seems to depend on a prior point, which is almost a definitional thing, that an operator cannot be an occupier. And so I'm not sure how you get support for that from this relevant person argument. I can see that you say, well, the relevant person provision can accommodate that definitional move, but I'm not following why it supports it.
My lord, the challenge that the statute lays down is to work out who the relevant person is, given that they're not defined in any other way than in 20 subsection 1.
As I was seeking to follow your argument, you say, well, because an operator can't be an occupier, relevant person must mean someone other than the occupier in a case where the operator is the occupier.
Well, the operator can't be the occupier and have code rights imposed on it.
Right.
There has to be two to tango for paragraph 9, and there has to be 2 to tango under paragraph 20. There has to be 2 separate parties.
But I thought this was an alternative argument. I thought the primary argument is the operator is not the occupier, because otherwise the code doesn't work. Right.
Yes.
And this point is, well, even if the operator is the occupier, then you get round the problem of paragraph 9 by saying that the relevant person can be somebody other than the operator occupier if, which we don't agree, the operator is the occupier.
Yes.
So I don't think that this argument supports the argument that the operator is not the occupier. Rather, it's a second argument if you're wrong on the first point.
It is.
Yeah.
It is. It is. It's another. Milady, it's absolutely. So this is a different way of reaching the same destination, but it is a different way, and it's a completely different way of.
So if the drafter, which might have saved everyone a lot of trouble, had split out paragraph 20 to have paragraph 20 dealing with just the operator, just with the conferring of code rights, and then a new paragraph dealing with the otherwise bound by a code right, I think the respondent's case would be that in the first paragraph just dealing with conferring a code right, it would say occupier rather than relevant person, and in the split out one dealing with otherwise bound by, it would say the person to be bound by the right. And they say, well, because the drafter has squashed them together, they've got to come up with this relevant person to encompass both. Right, but if it was split out, under your version, what would you say they would still use the phrase relevant person, even if they were only dealing with what's in 21A, conferring a code right?
So, my lady, we put it the other way around. Oh. We say paragraph 20 does not say after the words requires, so it doesn't say this paragraph applies where the operator requires an occupier under paragraph 9 or a person otherwise bound under paragraph 10. It doesn't say that. Nor is, and another way it could have been dealt with, there could have been a 10A, say, which said a person who has conferred a code right under paragraph 9 or is otherwise bound under paragraph 10 is a relevant person for the purposes of paragraph 20 below. Could have said that. We say it doesn't. What it does do is introduce a brand new concept, which is relevant person. And that must mean something different from occupier in para 9 or person who agrees to be bound under para 10. It must mean something else. And what it means is, it means the person who's the capable grantor.
But it doesn't say that. I mean, your problem is that if you cut loose a relevant person from being limited to the by paragraph 9 and 10, then it can mean anyone in the world. It's another way of putting Lord Sales's point, that you've got nowhere then to define who the relevant person is other than those paragraphs in the code.
So we say one has to read it...
Just have to make something up.
One has to read it in the context of a common sense, workable, pragmatic solution, which reflects the policy of the code. We have to make this work, and it makes it work to say, because there are all these problems that Miller and Friend outlined, and I will also allude to with the other solution, we have to make this work, and the only way to make it work is to say relevant person is the competent grantor.
I mean, you say relevant person is a new concept, therefore has to be given a new meaning, but I'm not sure that I'm following that, since one can marry up pretty clearly 21A with paragraph 9 and 21B with paragraph 10, which are already categories of person, important categories of person under the code. And on the face of 21, you can perfectly sensibly see what the drafter seems to be wanting to do. As my lady says, the drafters simply squash together these two categories, and they want to produce a regime that will cover both of them. How does one tell whether that's the proper interpretation, or whether it must be a new concept being introduced is the proper interpretation?
The answer to that is, which I'll come on to, is that there are provisions in the rest of the code which mandate a solution to this problem. And we've mentioned them, and I'll mention them again in a slightly different way. Paragraph 27, paragraph 40, subsection 8, paragraph 26. There are these problems with the Court of Appeal's solution. We concede that there's nothing in those provisions which mandate the competent grantor solution. They show that a solution to the Compton Beauchamp Ashlock problem outcome is needed. And we simply say that construing relevant person in that practical, pragmatic way as the capable grantor solves the problem.
Yes. So with Lord Sales and Lady Rose's point is that paragraph 21A and B can be an explanation why the expression relevant person is used, but you say you can also use that expression as a springboard for solving a problem.
Indeed, and it's notable that that 20 doesn't hark back to 9 and 10 when it could so easily have done so.
Perhaps can I put it another way, which I think may be the same as everybody else has been saying. You would have expected a term like relevant person in paragraph 20, irrespective of your argument, because you're going to have to deal with both paragraph 9 and paragraph 10. So relevant person would be an obvious term to use in order to reflect the difference between paragraph 9 and 10. But you want to say, well, that may well be the case, but in any event, it is a different term and it can be given a wider meaning.
But indeed, but my lord's perspective, with respect, doesn't address the fact, firstly, that relevant person is not signposted in 9 or 10. Secondly, that relevant person in 20 does not in any way but very, very subtly hark back to 9 and 10 when it could have spelt out that it's talking about 9 or 10. And thirdly, doesn't explain why this concept relevant person is introduced for the first time at this point and not earlier. And my Lord Sales is asking for is asking for more than my theory supports. I have to concede that relevant person doesn't follow expressly. We're just saying it's something that this court, or any court, is Judge Cook, for instance, is entitled to read paragraph 20 like. Because there are such problems with the other outcome. And we say that there's a problem here which really needs to be solved, and this is one way of doing it, although we agree it doesn't signpost the exact solution perfectly. We're inferring it. And what we say is that it's not mandated by the code, this solution, but it fits. It fits the wording of the code and it fits the policy of the code.
This may be the point for me to ask another question, which is related to what you're saying, which has been puzzling me. In paragraph 31, page 1834, dealing with how may a person bring a code agreement to an end, we've suddenly got another concept, a site provider.
Yes.
And I couldn't... well, first of all, the reason for this observation is I couldn't see why that concept was being used, which I don't think has been defined. Yeah. But the reason for raising it now is, if relevant person had the significance you are seeking to say it has, why wouldn't that concept have been used in paragraph 31?
My Lord, the problem's even deeper than that, because you have a code where The person we're talking about, which between your lordship and I we can call the landowner, is defined as relevant person in Part 2, relevant person in Part 4, site provider in Part 5, as your lordship's noticed, and then landowner or occupier in Part 6. So each part seems to use a different nomenclature for the person that's providing the site. And that can only be because to a significant extent, these parts stand alone. And therefore, that's one of the reasons why we don't accept that paragraph 20 subsection 1 necessarily in Part 4 necessarily drags us back to paragraphs 9 and 10 in Part 2.
How can that be right? I mean, surely paragraph 31 has to cover a case where the code agreement is one that has been imposed on the parties.
Well, the site provider would also be the relevant person. The site provider will have been the relevant person if this imposition of code rights occurred through Part 4.
Right, but, well, coming back to my question, if relevant person is a concept of such significance as your submission would have it throughout the code, as opposed to just having significance for the purposes of paragraph 20, because the two things have been squashed together, why has the drafter not used that concept in paragraph 31? And it may be in part 6 as well.
No, my lord, I don't say that relevant person has a great significance throughout the code.
Right.
Relevant person is simply a Part 4 thing. It's simply a paragraph 20 thing. It's only about when you are dealing with paragraph 20, the concept you have to grapple with is relevant person.
I see.
Well, what your argument requires is that paragraph 20 has been drafted so as to provide for an operator to require a person to agree those things without any specification within the code of who counts as a relevant person.
My lord is absolutely right, it's undefined. So we have to do the work to fill it in, and to say that it's the person capable of making the grant, we say is a pretty commonsensical outcome, observation.
And you might say that as what we're talking about here is necessarily the court imposing the agreement, that one would hope would result in only a person capable of conferring the code right actually being subject to the court's order.
Absolutely, my lady. This is a court. This is a court-supervised process, and we say we say who else could it possibly be? It's the person who can give the right.
But that makes you ask, well, who can give the right? It doesn't tell you anything, does it, to say it's the competent person? Because who can give the right is something which the code decides.
It's the next person up the chain legally able to do so. So on a new site, it's the occupier. If the operator is the occupier, it's going to be the reverse.
When you talk about the chain, you mean the chain in paragraph 105? No, because that's the meaning of the occupier.
The chain of property interests. The chain of property interests, my lord, is going to be the reversioner on the occupation. That is, the person next entitled to the land once the occupation comes to an end for whatever reason.
Well, in practice, it's going to be the person who's actually currently giving the rights to the operator.
In practice, this is going to be no problem at all. Of course, this whole thing is a purely court-made problem.
But there's no a priori way of telling who can give the rights. The code has adopted a particular approach, which says in paragraph 9 that it's the occupier, but it could have chosen all sorts of other approaches, identifying the person who has the freehold interest or the leasehold interest, or
Indeed.
It's just adopted a particular concept.
Yeah,
so if you abandon that concept and say, well, it's the person competent to grant the right, then you need some other concept. which the code doesn't give you, of who has competence for that purpose.
Well, it's going
You fall back on property law? Is that your approach?
It's going to be a legal answer. It's going to be a legal answer as to who can give the right.
A whole thrust of your submission is that this is not based on property rights, this code, and so we don't look to property rights to say who's competent to confer rights. We look to the code itself. And if you don't find the solution in paragraph 9, you don't find it anywhere in the code.
Well, my lord, we have to look somewhere. All we're saying is that we have to look somewhere for it, and the common sense outcome is it's the person who grants the right is the person who can grant the right. It's no more.
But who can grant a right?
Whoever can do so in law. Whoever's permitted to do so in law.
Under property law?
Property law, yes.
So after all, property law is very important to finding who can confer rights under the code. It's not as self-sufficient statutory scheme as you were advertising.
Well, in relation to this, the property rights are relevant, yes. And they, to some extent they have to be, because these are rights over land. Paragraph 3 is very clear that these are rights over land. Every single code right, my lord, pretty much, in paragraph 3, uses the words over the land. So A, over the land, B at the end, over the land. They all seem to include the words towards the very end of each code right, over the land. So yes, one is saying that the concepts of occupation have been overdone. But we can't also say that rights over land are irrelevant to a situation where pretty much 8 out of the 9 code rights are rights over land. So your lordship has forced me back a little bit there.
Right.
Quite right.
So can I just ask a further couple of questions? One is, I'm just having problems conceptually within the Act in having what appears to be, on your approach, a mismatch between paragraph 9 and paragraph 20, because you aren't saying that there's anything in paragraph 9 that we need to read purposefully or anything of that kind. It's only when you get to part 4, paragraph 20, that this relevant person purposive interpretation really kicks in. So that's one problem, that you seem on the face of it to have a mismatch. The second is that if your argument is correct, why isn't the relevant person the site provider?
My lord, the fact that parts 4, 5 and 6 use separate nomenclature for the same person is very difficult, because that question could be directed to any of those 3 concepts. One could say, well, why is site provider not used throughout? Why is landowner not?
I didn't actually mean that. It's just conceptually it would be very odd to, this is how you make an agreement. We've then got an imposition of an agreement, but that doesn't marry with if you make an agreement without imposition by the court. In other words, you'd expect the imposition of the agreement by the court to reflect the fact that you can make this agreement in certain circumstances. That is, that those people can make an agreement, that is the occupier and the operator.
Yes, but if I could...
Yes, sorry.
Your lordship's questions are linked, because we do downgrade paragraph 9 to say that it assumes an occupier who isn't the operator. It's written on that assumption.
Well, I'm afraid I'm back to Lady Rose's point on that. I thought this was an alternative to the argument that was being put forward yesterday. I thought you were effectively assuming that occupier and operator, even if the operator is on site, that is perfectly acceptable under paragraph 9.
But my lord, I'm not using to get there any of my learned friend's arguments about paragraph 100 or 108. I'm using different materials. I'm saying you only have to look at this, paragraph 9, to see that it's written on the assumption that it assumes two people, not one person, which is all you have when you have an operator in occupation.
But I mean, you may be using different materials, but the sort of conceptual move is the same, isn't it? You're saying paragraph 9, when it talks about an occupier, excludes operator. So an operator can't be an occupier, which is the same move that Mr. McGee makes, referring to other provisions. That's why I was trying to put to you that your argument in relation to relevant person seems to depend upon a prior definitional move, which is the definitional move in relation to paragraph 9, that an operator simply cannot be an occupier for the purposes of the code. That's it.
My lord, I wanted not to put it that high. I wanted just to say this assumes, this paragraph 9 is not written on the assumption that the operator is in situ.
All right.
Because it just doesn't make sense in that situation. We're simply saying, of course, my learned friend's arguments are our fourth ground of appeal, of course, but we're simply saying it doesn't purport to deal with the situation where the operator's in situ. It just doesn't contemplate that situation. That's all.
Yes. Could I ask you one relatively small question on paragraph 31 and this concept of a site provider? And I just wanted to check that I was understanding correctly. That seems to be a concept which is intended to cover anyone that can be subject to a code right. And we've looked at the code rights under paragraph 3, and several of them don't have to be in relation to the land where the ECA is located. We talked about the lopping of the trees and so on. The language, a site provider, seems to be redolent of the person that's providing the site for the ECA, but I just wanted to check I wasn't misunderstanding that, in fact, site provider means anyone who has land which may be subject to a code right, even if it's not the site for the location of the ECA. Is that the correct reading?
Well, my lord, site provider is defined in 30 subsection 1.
I see. Sorry, that maybe, yeah, that probably is the answer then, isn't it? It marries it all up.
It's actually the same definition as your lordship.
So which section is it?
Section 30, subsection 1A.
Page 1833. Yes, I'm sorry.
Now, my lord, it's a significant...
So just so that I get it clear in my mind, so by virtue of that definition, that does cover everyone who may be subject to a code right. Is that right?
Even if the site they have has got the tall tree rather than the mast.
That's what I'm asking.
Yes, but the definition that your lordship sees in 30 subsection 1A raises a question that harks back to the discussions of moments ago, which is why is that definition, why is that wording not used in paragraph 20 instead of relevant person wording if my Lord Legate's thesis is right, that in fact 20 subsection 1 is just harking back to 9 and 10 and that's it. That same wording could have been used, but that wording isn't used, and the new concept is introduced. Your lordship has my point. So we say this is one way which fits everything else, and in particular it fits the problems that have been identified, and I will only address this to the extent that I can add some value on it. But there are 4 other provisions that won't fit the Compton Beauchamp Ashlock analysis. The first is paragraph 26, which my learned friend dealt with, which allows ECA to be on site already. It may or may not be there, but it can be there. The most striking, perhaps, though, is paragraph 27. Paragraph 27, which is on page 1826. Paragraph 27 allows the operator to apply for temporary rights and actually has as conditions two things. First of all, a notice under paragraph 20, that's 27(1)(a). And the other condition it has three in all, but the second one is that ECA is already installed on, over, or under the land. On, under, or over the land. That's the end of 27(1)(b). So the two relevant conditions to this are a notice under paragraph 20 and that ECA is already installed. So this must mean that an operator can apply under paragraph 20 while having ECA on site, that is, while being in occupation. It's impossible, we say, to interpret paragraph 27 in any other way. It can have no application if the operator is not already in situ. And that's why Judge Cook, who was, of course, the Law Commissioner involved in drafting the Law Commission's recommendations, was so horrified at how the Compton Beauchamp and Ashlock decisions had come down, because she remarks that those decisions rendered paragraph 27 almost useless, very, very short term, in the very situations where they're designed to be of most use. She mentions it in a very careful leapfrog certificate. The reference is page 1722 at paragraph 15. Paragraph 27 becomes practically useless in that situation. So, a good example of paragraph 27. The question's often asked, what's the difference between 26 and 27? The one answer is that 26 is for short-term arrangements, so like a music festival where greater power is required, or a royal wedding in Windsor takes place, and greater power is required over a very short period of time. So paragraph 26 allows for a short period of time the operator to go on land to acquire code rights for the greater need. 27 is more permanent in a way, even though they're only called temporary code rights, because paragraph 20 has to be set in train under paragraph 27. It has to be. There has to be a notice under paragraph 20, subsection 2. So,
the odd thing is that really the titles of these two are the wrong way round.
They are the wrong way around, my lady. No question. In the University of London case, one said that to the Court of Appeal without much demur. It would appear it's much easier to think of them if you swap the titles. So 27 is really about rights that are interim to the hearing of a paragraph 20 application. And the outcome is absurd because, as Judge Cook pointed out so carefully, the Ashlock and Compton Beauchamp outcome consigns the paragraph 20 notice, which is a condition of paragraph 27, to being struck out the moment it's born. And that just doesn't make any sense. So,
can I just check? You say would make it practically useless. Is that to accommodate what would seem to be a very rare case where ECA is on the land, but I don't know, perhaps the operator has abandoned it, and so it doesn't constitute land in occupation of the occupier? I think what I'm asking is, conceptually, are there cases where ECA can be on the land, but the operator isn't in occupation? I mean, I would have thought that that conceptually could be the case. You know, they put the material, the equipment up sometime in the past, that they've now got another mast, they don't need to use that one. Essentially, they've just abandoned.
Could be.
We were given the example yesterday of the mast on the roof or something. The person might not be, the operator might not have such a presence as to count as occupation.
Yes.
They may not have fenced off the mast, or it may just be land which they need to enter on for the tree lopping purpose, couldn't it? I mean, there are plenty of situations where the operator is not in occupation. But your point is that a major occurrence is the operator in situ, and it's rendered pointless in that situation.
And that's what, and that was why Judge Cook was so horrified. So the point is this, my Lord. I accept that the relevant person test is a pragmatic leap. It's a, and I've been criticised for this by my Lord Legate quite rightly. It's a property lawyer's leap to say, well, relevant person is competent grantor. But we have to do something to save these provisions from nonsense. 27 is one. There is also 40 subsection 8. My learned friend, Mr. McGee, has dealt with this, but the short point is that 40 subsection 6 allows the occupier, that's called the landowner or occupier, to make an application to the court for an order that ECA be removed. But then, so the ECA is installed on the land, it is there. The operator is in occupation in most cases. But then, subsection 8 says, on an application under 6 or 7, that's the landowner or occupier's application, the court may not make an order in relation to apparatus if an application under para 20, subsection 3 has been made in relation to the apparatus. So Parliament's intention as regards operators in occupation being permitted to make an application under paragraph 23 when they're in occupation, their equipment is on site, is here. And Parliament intended that a paragraph 20 subsection 3 application can be made in relation to ECA already installed on land that's occupied by the operator. How? Well, one answer is because relevant person in paragraph 20 means the person competent to make the grant. It's a practical answer. I wanted to deal with the transitional provision.
I think you said there were 4 other provisions.
So
26, 27...
26, 27,
40...
40.8, and the transit... The other provisions I need to deal with are the transitional provisions. In the Queen's Oak Farm case, in the case that I'm instructed in, the operator does not have a subsisting agreement. And the reason why it doesn't have a subsisting agreement is because the definition of subsisting agreement in paragraph 1.4 of Schedule 2 is an agreement for the purposes of paragraph 2 of the old code, and the old code in paragraph 2.1 said the agreement had to be in writing, and the tenancy at will is not in writing. But what we say about these transitional provisions is we don't need to be covered by the transitional provisions. We're not saying that there is a new code version of our existing tenancy at will. What we're saying is that once one appreciates because of paragraph 3 and 22 and 27, that the operator in occupation must be able to give a notice under paragraph 20, even if it's in occupation, the transitional provisions are irrelevant. It's not really about the transitional provisions, or in other words, the transitional provisions in Schedule 2 don't need to deal with the tenancy at will, or periodic tenancies for that matter, because in Schedule 1 there is a new code with a Part 4 drafted, we say in broad terms, with the concept of relevant person, which gives the rights to operators, whether they're in occupation or not, to seek code rights where they don't have any. And that, we say that's exactly the position we're in. And we say the misconception in the respondents' arguments in relation to the transitional provisions is just treating them as if they're something on their own. Their whole point seems to be, oh, well, tenancy at will is not included in the transitional provisions, nor are periodic tenancies. They could have been included, but they're not, so you're out. But we say that's the wrong way around. The transitional provisions didn't need to deal with tenancy at will or periodic tenancies precisely because operators without code rights can seek them under Part 4. The transitional provisions are just a part of the suite of legislation reflecting the thrust of the Law Commission's recommendations. And the transitional provisions don't say they're intending definitively to deal with every existing property interest. They only deal with very specific situations. Fixed-term agreements which cross over into the code date. Then, when you have ongoing 1954 Act tenancies, the transitional provisions provide a way of retiring them that the learned friends explained. And also where old code notices have been given under, this is transitional provision paragraph 11, they are transitioned into Part 4 under transitional provision 11.2. As we say, this tenancy at will is. But we say there's no need for the transitional provisions to have dealt with the position. Now, my Lord, I said that there had to be a solution, and relevant person was a solution, because it fitted and reflected both the wording of the code and the policy of the code. The policy of the code, I've dealt with wording, the policy of the code is to deliver land cost savings for operators, to invest in the development of their technologies, to meet government targets for rollout, and to bring the cost of access to land for ECA more in line with other utilities. That's the policy of the code. And the striking thing about the Ashlock and Compton Beauchamp outcome is that it makes the position of the operator worse than it was under the old code. I wonder if your lordships would allow a quick look back at the old code, which is from page 1902. Paragraph 5 of the new code is on page 1907. And the top of page 1907. And the first thing one notices about paragraph 5.1 is headed power to dispense with the need for required agreement. And it says, where the operator requires any person, so it could not be wider, for the purposes of paragraph 2 or 3, that any right should be conferred, operator may give a notice. Now, we know that paragraph 2.1 of the old code required the agreement in writing of the occupier for the time being and the operator. But there were two express powers of dispensation under the old code. The first is in paragraph 5.4, paragraph 5, subsection 4, on page 1907. The dispensing power is referred to. It provides an order under this paragraph made in respect of a proposed right, may, in conferring that right or providing for it to bind any person or any interest in land, and in dispensing with the need for any person's agreement. So there's a power to dispense with the need for the person's agreement under paragraph 2. And then the meat of it is in paragraph 7, which says, where an order under this paragraph for the purpose of conferring any right or making any provision for a right to bind any person or any interest in land dispenses with the need for the agreement of any person, the order shall have the same effect and incidence as the agreement of the person, the need for whose agreement is dispensed with. So it's a fantastic dispensing provision. It basically says, don't worry about the need for agreement under paragraph 2 or anywhere else. We're dispensing with the need as if the person who needed to agree that requirement had been dispensed with. Now, the explanatory notes confirm that Part 4 is a direct replacement for this paragraph. But now we are worse off. The operators, in a code that was supposed to benefit them so as to deliver land cost savings, are much worse off. Because now all the operator has in a case like Queen's Oak Farm is that the site provider has to follow the processes in Part 6 to enforce the removal of the ECA. That follows from paragraph 100. But that's it, really. We can't even use paragraph 40 subsection 8, because paragraph 20 is closed off to us, despite paragraph 48 on any normal reading suggesting that paragraph 20 is open to us. It's what we called in our case a black hole. And it could not have been the policy of this code that operators were going to be worse off in respect of some 2,000 sites. It just doesn't sit with the policy of the code, but actually worse off. Now, Malone and friends for the respondents say 4 things against us. If I could deal with these briefly, I've dealt with some of them already. The first one is about consensual agreements, which Lady Rose picked up. They say it's odd that a consensual agreement can only be entered into between the operator and the occupier. But if the attempt at consensus breaks down and the court imposes code rights, under paragraph 20, such rights can also be imposed on the non-occupier. So this is the point about the dissonance between paragraph 20 and paragraph 9. And our answer is simply that the assumption is wrong. You can enter into consensual code agreements because it's in the nature of the agreement that the parties are treating the site provider as the occupier. And also, that's the first level, and the second level is because we are still left with something regulated by parts 3, 4, possibly 5, and 6. The second thing said against us is that this solution would sidestep in some way the 1954 Act. It said that on the basis of our argument, a periodic tenant could just sidestep its existing obligations under the 1954 Act and go straight into the code under Part 4. The answer to that is yes, but it still needs to make the application. It still needs to get into the code, and under Part 4, it has to pass the public benefit prejudice test. And those tests are harder than the test under Part 5. So, yes, the periodic tenant could move straight into code, but it has to pass the tests. The third point...
Are you relying on the court's discretion?
Yes.
To that extent, yeah.
Public benefit. It has to be of an additional public benefit.
Yes, I mean, strictly, that's not a point of discretion, is it? I mean, you actually have to...
You actually have to satisfy.
Before you get to the discretion.
Yes, my lord, that's right. It's not a point of discretion. It's the actual public benefit test. The third point is it's said against us there has to be a concept of occupation that regulates the position between occupiers. This is the so-called blue-on-blue situation. What's said is, if you ignore occupation as an essential element of the conferral of code rights, then O2, the second operator, can come along and seek code rights from the landlord, whilst O1 is already in occupation. And the point that's raised by my learned friends is, well, how can the landlord, the landowner, in those circumstances, confer the right to immediate possession on O2? What if O1 needs not to have a sharing because it's carrying out services of sensitive national importance, or emergency services, as is common? The answer to this, I think, has to be, and my Lady Rose canvassed some of this with my learned friend Mr. McGee, the answer is to see there are two very different situations that we're talking about. The first situation is where O1 is on the site with ECA, and O2 comes along and wants to put O2's ECA on O1's ECA. In that situation, it's nothing to do with code rights, because paragraph 3 says code rights are rights in relation to land, in, on, or over land, and we know that land is not ECA from paragraph 108. So this will be most cases, not least because of technical reasons and because of the wide definition of ECA in paragraph 5.
What do you mean it wants to put its ECA on O1's ECA?
It wants to put antennae on O1's mast. This is going to be the majority of situations, because ECA is defined very widely indeed. It's defined in paragraph 5, but the wording is of the widest possible sort, not just because in A and D the expression used is in connection with the provision of electronic communications network, so it only has to be connected to the provision of the network, but also because of the word things in D, other structures or things. One can hardly imagine a wider word than things. So ECA is defined widely, and in the vast majority of cases where O2 wants to put its antennae on O1's mast, it won't be about code rights at all, because that mast is not land. Then there is,
what does it do in those circumstances then? If it wants to do that, who does it have to? You're saying it's not a code right, or
it's not a code right. It has to. It's dealt with it on a regulatory level by Ofcom. In order to become an operator under this code, certain commitments had to be made. One of them was to share. There's a regulatory process whereby Ofcom regulates between O1 and O2, and that's how it would be dealt with if there was a problem. The second situation is completely different. That's where O2 wants its own mast on land which is leased to O1. And that's a completely different situation. So O2 wants its own ECA, its own mast, but not on O1's mast. It wants it on O1's land. In that situation, the relevant person, we say, for the purposes of paragraph 20, is O1. And they're the relevant person because they're the capable grantor. They're the person you look to. So we say, well, O2 has to go through paragraph 21, and O1 is acting qua landowner, site provider. But of course, the Ofcom regulates that situation too. So in practice, it's not going to happen. The final point made against us, the fourth and final point made against us, is a point picked up by my Lord Sales, which is that occupation is just a more convenient test in practice. And this relates back to Lord Justice Morritt in the Bridgewater case. My Lord, the position is really this. finding who has a right in land actually arises in almost every transaction where the grant of rights is concerned, whether property or contractual. And as my Lady Rose remarked to my learned friend, Mr. McGee, these are substantial transactions using conveyancing solicitors, and no conveyancing solicitor would allow a client to execute an agreement and pay money over before checking that the person granting the rights had the entitlement to do that. So in every conveyancing situation, the position's always the same. The register of title has to be checked. That will show the freeholder, and it will show leases of 7 years or more, because it's required to under the Land Registration Act 2002. And the position on the register then has to be checked off with the position on the ground. Inquiries have got to be made. So identifying the presence of persons with a right in land who are not on the register, say because they've got leases of less than 7 years, is an issue encountered up and down the land by conveyancers every day of the week. It's not particular to this area of the law. It's not particular to these provisions. And being realistic, in almost all cases, the competent grantor is going to be the occupier, except where the operator is in situ, in which case it'll be the person immediately entitled to the reversion on that occupation. It will be the farmer, if this is a greenfield site, or it will be the university, if this is a case like University of London, or it'll be the department store on whose roof the ECA is placed. It's pretty easy, actually, to find. That's the practical reality of it, and that's also the common sense of the relevant person test. It's going to be obvious in most cases who it is. It's the farmer, it's the department stores, it's the university. So, to conclude, we say our interpretation is a way to give meaning to the words used in 27 and 40 subsection 8 and 26. It's consistent with the transitional provisions, and it's consistent with the policy underlying the code. On the respondent's interpretation, we are in a worse position than an arriviste, someone coming new, and we're also in a worse position than we were under the old code. Why would Parliament have intended, in a code designed to reduce land costs for operators, to put the operator in a worse position than it was before, and a worse position than someone coming to this new? It makes no sense at all. And it leads to, and this is what this case is really about, it leads to ransoms. And my Lord Burrows said, why hasn't this issue not arisen under the old code? And the true answer to that is there wasn't the money at stake. Because under the old code, it was done on the basis of market value, and parties agreed those values. And it didn't matter if the operator was in or out of the code, market values for consideration governed the position both ways. Now, there is a no-network assumption under the code, an assumption that this is not being used for telecoms use. And that makes it much more profitable for intermediaries like AP Wireless, like my learned friend Mr. Piemont's client, who insert themselves between the farmer or the department store and the operator to say, you're outside the code. Because then they say, you're outside the code, what can we negotiate on the assumption that there is a network because you're outside the code? And to get around the problem, to get around the problem that the Courts of Appeal have created, we have to contort ourselves. One thing we could do is go out of occupation of these sites and then go back in under Part 4 as an arriviste. Well, it's absurd. Judge Cook was right to say it would be a waste of time and effort. But much more important than that, it's an interruption to the service. It's the customers and the emergency services and the like, whilst we're out of occupation, won't be able to receive calls or make calls. We could try convoluted agreements with shell or group companies, but they'd be very complicated. Or we could just, worse of all, we could abandon perfectly good sites that we've had like this one for 20-odd years. We could perfectly well, serving the community in every single way. We could just abandon them. That cannot be what Parliament intended by this code. And so, my Lord, I'm not saying poor me, poor operators. I wouldn't dream of saying that. We're saying this outcome could never have been intended by Parliament. Unfortunately for your Lordships, there are ways to avoid that outcome. There's Miller and Friends way, there's a relevant person way, and there's one more. There's one more way of avoiding it, a route to Miller and Friend, Mr. McGee's outcome, which actually doesn't depend on code. It's another colour of paint to put on your Lordship's palette to get out of this problem. And with your Lordship's permission, I'm going to swap seats with Miller and Friend, Miller Junior, Mr. Kitson, to address you on that.
Thank you.
My Lords, my Lady, you've heard from Mr. McGee and Mr. Seitler two possible solutions for the problems that arise by virtue of paragraph 26, 27, 40, subparagraph 8 and the like. We say that there is one further solution, and it's a solution that addresses what has to some extent been the eliding of property rights and non-property rights with code rights. The crux of On Tower's contention on this solution is that where there are renewed agreements, and those agreements have been made consensually or imposed by the Upper Tribunal, there must be two successive transactions. Firstly, there is a surrender of an existing interest in land or a rescission in the case of a contract. And secondly, there must be a subsequent grant of either a new interest in land or a contractual right that gives effect to the operator obtaining the necessary code rights. And we say that for a fraction of a second, it's referred to in the statements of case, and indeed one of the authorities before you, the case of Abbey National and Mann, a scintilla tempori. For that split second, the operator is no longer in occupation, and the occupier, as required by paragraph 9, is satisfied. At the very moment we say that the site provider grants the code rights, the law takes him, through a long-established principle, the common law, to be the occupier, so that the requirement of occupation in paragraph 9 is met. We say that this is a scintillating answer because it doesn't require your lordships and my lady to seek to find ways around the definitions in relation to both occupier and indeed relevant person that Mr. Seitler has addressed you on. It's scintillating also because it applies both to the consensual situation, such as where a site provider wants to make a consensual grant to an operator, It also applies in the case of imposition by virtue of the way that the code is written in Part 4, that it is an agreement that is imposed, and that agreement is as between two separate parties. My lords, my lady, we take no credit for originating this alternative or further solution to the conundrum that you need to decide in this appeal. Indeed, we can see very clearly from the judgment of the Deputy President, Martin Roger QC, and former land lawyer, that he saw this as being the absolute solution to the problem that you are having to decide today. And we see that at paragraph 82 of his judgment at first instance. I don't propose to take your lordships and my lady to that judgment. It is set out, the relevant passage is set out in our written case, which you can find at page 1422. And in particular at paragraph 102, where we've set out the very paragraph upon which, for my argument, we rely heavily.
So this was paragraph 82, this big idea, the scintillating idea, it was the Deputy President's idea, and it's in paragraph 82 of his judgment in Compton.
That's correct, at first instance, my lady. I've set out that passage in paragraph 102, but the critical parts, if I can break them down, are firstly that there seems to be no hesitation that, from the Deputy President that rights may be conferred on an operator who is already in occupation, which is, of course, the argument or the end point that both Mr. McGee and Mr. Seitler have been addressing you on. So there's no doubt there, and indeed he specifies specifically voluntarily or by compulsion in that first sentence. Further down in that paragraph, he says the same parties entering into a new agreement on different terms will be that the previous agreement will be terminated by operation of law. And that indeed is our point, that there must be a termination of the previous agreement. He says where the agreement is consensual under Part 2, the operator will not be able to suggest that the site provider was not the occupier at the moment the agreement conferring the rights was entered into, since otherwise paragraph 9 would prevent the agreement having effect at all. Now, we say that one of the most significant points arising from that sentence is that the Deputy President is making it quite clear that there is some, by virtue of making the grant, the site provider, even though they are not in occupation, are not able to say that they're not in occupation. He goes on that the position is the same in Part 4, and concludes in that paragraph the tribunal can compel the grant of new rights by a site owner to an operator which is itself in occupation, which is reasserting the very first sentence, but it cannot compel the grant of rights by a person who is not in occupation to an operator who is not in occupation. Now, the reason he says that at the end, of course, is that the facts in Compton Beauchamp was a tripartite situation. And so his judgment was very much based and aimed at the fact that a tripartite situation was under the consideration of the tribunal. Now, what we say is that we're in a bipartite situation, and therefore we can rely, and indeed we rely heavily, upon the fact that as soon as you're in a situation where a new agreement is entered into, you have that scintilla tempori, or that fraction of a second, when the basis of occupation must change for the purposes of the code, and it must change because the operator has to come out of occupation, we say, during that split second, for the site provider then to be able to grant the rights under the new agreement.
How do you conjure up that second, since what terminates the previous agreement is the making of the new agreement?
Well, we say that this is why we put it on the basis of a scintilla tempori in that situation.
Well, I mean, you can't just magic a gap when what causes the termination is the new agreement.
Well,
you have to find the termination first, and then a new moment when the new one comes into effect. But if what brings about the termination is the new agreement, there's no scintilla.
My Lord, you're right in some circumstances, or your analysis is correct in some contexts, and there is a case relied upon by APW and Mr. Pymont, where there's a lending situation, where the House of Lords, Abbey National and Cannes, the House of Lords found that there was a single transaction, and on that basis rejected the contention that there was a scintilla tempori in that case for the purposes of a party obtaining prior equitable rights. It's a case that I will come on to in the course of my submissions.
But I would have thought one would say that having a new agreement replacing an old agreement is different from varying the old agreement. And the difference is that there is this surrender or termination and the coming into existence of the new agreement, which is not a variation of the old agreement, but a replacement of it. And isn't it that then supposes, because of that distinction, that there is this fraction of a second in which there is no agreement?
My lady, we say that you're right in drawing that distinction as between a situation where there is a variation and a situation where there is a regrant, and that is in the case of a regrant there is that fraction of a second. In the case of a variation there isn't, because there is no surrender or rescission of a contract and then the grant of a new agreement. So we very much put our case on this in the terms that my lady has outlined the difference between a variation situation and a regrant situation, whether that be a regrant of terms of a contract which doesn't involve interests in land, or whether that involves the regrant of a lease, or indeed an easement, or some other right that does take effect as an interest in land. We say that what the Deputy President says in paragraph 82, it reflects a long-standing principle, common law principle, in how, by way of example, surrender and regrant has been analysed. And we say that it's an elegant solution because of its simplicity in dealing with the necessary occupation requirement in paragraph 9 without the need to construe the code in particular ways. And that the Deputy President is absolutely right in that analysis. Now, there are two further points that arise in relation to this. The first is that in the Court of Appeal, where we had very detailed analysis, particularly by Lord Justice Lewison, this paragraph was not doubted. neither he nor any of the other justices cast doubt on that analysis given by the Deputy President in paragraph 82, and we say that that must be in itself significant. The second point is what happens to paragraph 82 after the Court of Appeal had given their judgment in the Compton Beauchamp case. And this is the first instance decision in Ashlock, which followed that. And we can see in the Ashlock decision, I'll give your Lordship and my Lady the reference, it's at page 771 of the bundle, and it's at paragraph 78. The Deputy President distances himself or seeks to clarify paragraph 82 by referring to the reasoning of Lord Justice Lewison based on paragraph 34.8 of the Code. And your Lordships will remember from the argument and what was submitted in the by Mr. McGee that there is a fundamental problem with applying paragraph 34.8, which is contained within Part 5, to a Part 4 situation. But that is the only reason that the Deputy President gives in Ashlock for putting a gloss or distancing or clarifying, if we can use any of those words, on what he actually meant in paragraph 82. But of course, in paragraph 82, that paragraph also contains the unequivocal statement that an operator in occupation is able to get code rights. And of course, it's in the context of that we say that the Deputy President is referring to paragraph 34.8, because it's the use of that paragraph which is a key basis upon which the Court of Appeal and Lord Justice Lewison finds that an occupier in occupation isn't able to obtain rights because of the difficult wording that arises under paragraph 9 of the Code. Having said that, the solution is a good one, we say, and it's a good one because it applies both to leases and to contracts, to consensual agreements and to imposed agreements. Mr. Pymont, in his written note, and the other counsel representing ABW, is that the solution that we propose is one which is limited to proprietary rights, and we say that's just not the case at all. And an authority in Chitty on contracts is referred to by Mr. Pymont, and in particular the section dealing with rescission. But in that very part of Chitty on contracts itself, there is this very important wording, that rescission will be presumed when the parties enter into a new agreement which is entirely inconsistent with the old, or if not entirely inconsistent with it to an extent that it goes to the very root of it. And the change must be fundamental, and the suggestion is whether the common intention of the parties was to abrogate, rescind, supersede, or extinguish the old contract by a substitution of a completely new or self-subsisting agreement. So the solution of the Deputy President, or if I can call it out of reverence, the Deputy President's solution at paragraph 82, is one that is going to apply to the grant of code rights, which need to be renewed, both in contract, pure contract situations, such as an agreement to lop a tree, as it does to, for example, a lease. It applies in the context of a consensual agreement because if a site provider who is not in occupation wishes to grant consensually new code rights to an operator, then there must be the determination of the earlier agreement and this fraction of a second that my Lady Rose has referred to in the context of a re-grant situation.
Why would the grant of further rights be a termination and the creation of a new agreement rather than a variation?
Well, my Lord, that will depend on the nature of the consensual agreement that was entered into. And in all practical senses, operators who are looking for new agreements because their agreements that they're in occupation with have expired, such as in our case a tenancy at will, are going to have the grant of a new agreement. Where I think my Lord Hodge is coming at this question is on mid-term rights and the extent to which an operator might be able to obtain mid-term rights by variation of an existing agreement and seek the grant of further rights. Now, as Mr. Sietler has submitted to you, and I don't propose to duplicate in that regard, our answer to that is the same in relation to consensual agreements under the relevant person argument. That argument being that if an operator wants to vary rights and wants to grant code rights, then that site provider is accepting by a warranty of an implied warranty of being able to do so. He's able to grant those rights and is not able to say, for the same reason that we see in paragraph 82 of the Deputy President's judgment, he isn't able to say that the requirements of paragraph 9 have not been satisfied because he's granting the code rights.
Isn't that circular? I mean, this seems to come back to a point that was debated earlier this morning when my lady put to Mr. Sietler. In effect, the argument is almost like a form of contractual estoppel. Well, you have granted me these rights. You can't now deny that you are the person in occupation, however untrue that is by reference to reality. And I mean, looking at paragraph 82 of what the Deputy President said, I think that's what he is saying about a consensual agreement. He says, where the agreement is consensual under Part 2, the operator will not be able to suggest that the site provider was not the occupier at the moment the agreement conferring the rights was entered into, since otherwise paragraph 9 would prevent the agreement having effect at all. So he seems to be contemplating a situation where the parties can agree that whatever paragraph 9 says, they're going to treat one of them as being the person in occupation of the site for the purposes of this code. Isn't it the same argument?
My Lord, you're absolutely right. It is the same argument.
Okay.
And it just amounts to striking out paragraph 9, doesn't it? Because you couldn't agree with anybody that they're not going to treat, they're going to treat themselves as person entitled to grant the right or whatever. It just is a nonsense. Proves too much, the argument.
My Lord, we say it doesn't make paragraph 9 OTOs.
It just is effect saying if we agree that paragraph 9 won't have effect, then it won't have effect.
Yes.
Yes, but
I mean,
surely the point of the code is it's a system of, if you like, public law. It's setting out certain conditions that need to be fulfilled to acquire rights that have effect under this public law code. Ordinarily, in order to acquire rights under a public law code, you have to satisfy the conditions set out in the code itself. You can't agree between yourselves, well, this doesn't suit us. We will just agree that we have satisfied the conditions in the code itself. Because the code has effects on a whole variety of people. It involves mechanisms where you can go to the tribunal and so on. What the argument seems to boil down to is that the parties themselves, just by their agreement, can create jurisdiction for the tribunal, which is contrary to usual rules in public law.
Well, my Lord, what we say is that very clearly there was an intent behind this code to bring code agreements over time into the code so that operators, in years down the line maybe, but operators would all have rights under the code. And the difficulty one has in that context, and as a matter of policy, is that if they can't get into the code, they may never be in the code in relation to particular sites, because there is no way of getting into the code if you can't agree consensually, or you can agree consensually, but it doesn't become a code agreement within the meaning of code agreement in the statute, number one. And secondly, based on Mr. Piemont's argument, they can't even get it through Part 4. So in terms of policy, there must be some solution, we say. You've heard two of them. This is a third option on the menu, if I can put it that way, for being able to demonstrate that in the case of consensual agreements, if you enter into an agreement with an operator in relation to ECA and you're granting code rights, which Parliament has defined very clearly at paragraph 3 of the code, then in those circumstances, you have a code agreement. You're within the code, and paragraph 5, critically, is going to apply, because we know that paragraph 5 on its wording possibly will apply only to Part 2 agreements.
But in sort of outside the code...
Sorry, Part 5, not paragraph 5, apologies.
There's nothing out, looking at the situation outside of the code, there's nothing in law that prevents me from entering into an agreement with you to take a lease of Mr. McGee's house. And you can warrant that you're entitled to do that and indemnify me if it turns out you're not. But if you're not, there's no point me entering into that lease with you if actually you have no rights to confer, and there's no point you entering into that lease with me if you don't have rights to confer. People tend to enter into contracts with people who they believe or have actually got the rights to confer under the agreement.
My lady, we say that's right. And it must be right, because the first question to ask is, why would Parliament have purposefully prevented an operator and a landowner in the context of what we call WIPs, which are providers of telecom infrastructure to third parties, as well as possibly their own infrastructure? Why wouldn't they be able to enter into an agreement consensually, which is an agreement that's governed by the statute, with, for example, a party such as APW, which itself is a company which is very experienced in the context of providing sites, because that's very much what it does. Why would Parliament, we say, have prevented parties from being able consensually to enter into agreements which are governed by this code, and then providing, if they can't enter into consensually, a mechanism, we say Part 4, by which they can, the Upper Tribunal can impose a bilateral agreement between those parties to make sure that it does come within the code. And here we say it's a significant point, because why should consensual parties that can agree everything they want to agree for the purposes of conferring code rights be forced down a route where they don't get code rights consensually, such that they've got to go down Part 4 if it's available to them.
I suppose the answer to your question is that Parliament doesn't want to have competing agreements with different people who have an interest in the land. It wants to identify just one person who can make the agreement with the operator. That seems to be the system. That's why you have the sort of cascade of provisions for identifying the occupier, isn't it?
It is.
Later on.
Well,
So the answer to your question is they don't want to just leave it to the situation where if you'll say the freeholder, you might say, well, I've got some interest, so I'll make the agreement conferring the code right. And the tenant also thinks that they'll confer the code right. I mean, it's meant to identify so you know who you have to go to, isn't it?
well,
Is that the point?
my lord, yes, but why shouldn't a code agreement arise in those circumstances? Because you've agreed with somebody, having done your due diligence, instructed your solicitors, been content that you're getting a right and that the right can be granted. Why would you necessarily have to go down the code route in those circumstances? And in terms of people that are bound are successors largely, entitled to the person who grants the right.
Well, what's your explanation of what paragraph 9 is doing then? On your approach, why have paragraph 9 if it's anybody with an interest in the land who can make an effective agreement to grant a code, right?
Because we say
why have paragraph 9? What function at all does it serve?
Well, we say fundamentally that is reflecting the fact that consensual agreements, which we say are principally dealt with under Part 2, will be with an occupier of a site with nothing on it and an operator who wants to take the benefit of paragraph 3A of the code, which is for the installation of the ECA.
Well, maybe they will in practice, but why have what paragraph 9 says that it can only be conferred by the occupier? Well, what is the function of that? If your approach, you're posing the question, well, why not say that anybody with an interest in the land can confer a code right if they want to agree? Well, why have any restriction, you say, on freedom of contract? Well, you can ask that question, but clearly that's not the intention of the legislature, so you have to then make some sense of paragraph 9.
Yes, in the sense we say, and I very much, accept the strength of that point that my Lord Lord Legate makes. But we say that the paragraph 9, a code right in respect of land, and it's referring specifically here to land, may only be conferred on an operator by an agreement between the operator of the land and the operator, and that is aimed at the situation where you have I could call it a greenfield site, where the person who is in occupation of that greenfield site, occupation having been defined later in the code, and the various cascading levels of occupation, they are the parties or the individuals at which this is aimed at. What you can't do is, if you're not in occupation necessarily, is agree something which is going to affect the rights of somebody with an inferior interest.
Can I just go back to the Deputy President's paragraph on which you're relying? As I'm understanding it, there are sort of two ideas floating around here. One is the scintilla temporis, as you're putting forward,
yes,
and the other is the estoppel,
yes,
type of argument. Is the problem with the scintilla temporis that might be put against you that it seems to be assuming that you can always see in these situations one arrangement finishing and another one starting, as opposed to the continuation or variation of a single agreement. Isn't that the problem you've got to face?
Well, yes, insofar as in a regrant situation, we have the scintilla temporis. In a variation situation, we rely on the estoppel, as my Lord Burrows has characterised it. And we say that both work.
I mean, the scintilla temporis argument is just addressing a position in relation to contractual rights, but the underlying predicate for the operation of the code uses a different concept, which is occupation. I'm struggling to see why the scintilla, even if there is a scintilla temporis between two separate agreements, that has any bearing upon who's the occupier of the land. The facts on the ground will remain unchanged, whatever the lawyers are doing in their office.
Yeah, well, we say that, first of all, the effect of the argument is that you don't need to look to the effect on the ground because you have the grantor is not able to say that they're not an occupier.
Well, that's to go back to the contractual estoppel.
Exactly.
So, in fact, scintilla temporis doesn't then seem to be doing any work at all, and it is just a contractual estoppel point. If I understood correctly.
No, my Lord, you're absolutely right. One can look at it in either an estoppel. If you take the estoppel argument, then yes, it is going to cover the situation regardless of a scintilla temporis situation. We accept that.
Just looking at what the purpose of Article 9 is, there's this distinction drawn between people who confer rights and people who are bound by the right. And I'm wondering why you need to make that distinction. Why can't you just have everyone being bound by the right? Why do you have to identify one of the people who is bound as the person conferring the right? In Article 9 could have said the person who confers the right is always the freehold owner, and everybody else lower down the property law chain is then has to be bound by the right conferred. But in fact, they do it in the opposite direction, perhaps because of the Bridgewater, if that was it called, case, that, well, start with it being the occupier who confers, and then everybody else who needs to be bound by it is bound by it through 10.4. But there's consideration has to be paid to both the conferrer and the person bound. Is that right?
That is right, yes, my lady.
So that may be the curiosity, that they felt the need to identify one of the bound people as being the person who confers the right, and the rest aren't conferring but are equally bound the same way that the conferrer is.
And in the case of a site that has no ECA installed upon it, it makes good sense that it's the occupier of the site who's granting the right, who receives the consideration for the grant of that right.
But you would also want to, I mean, I don't know how many circumstances or how many sites there are, what proportion there are, where there are also have to be people bound by the right beyond the person who confers the right. I would guess in quite a few.
Yes.
I suppose the paragraph 9 identifies where you start with deciding who you need to get the rights from, or who needs to be bound by the right in order for you to be able to do whatever you need to do.
Yes, that must be right, my lady. One of the arguments that is taken against this point is that there are anti-avoidance provisions in the 1954 Act, and if it is to apply to the 1954 Act, then the effect of a tribunal imposing a code right in circumstances, or a court, in circumstances where there are anti-avoidance provisions at paragraph 38 and 38A of the 1954 Act, Landlord and Tenant Act, which you'll find at page 1951, is that there is some that there shouldn't be a situation where the tribunal can impose code rights in circumstances where there are these anti-avoidance provisions in paragraph 38 of the 1954 Act. What we say in response to that is that the anti-avoidance provisions in the 1954 Act relate purposefully to agreements to surrender, not the surrender itself, and therefore there is no problem that arises in that context.
So you can't agree, you cannot agree to surrender?
My lord, yes, you can't agree to surrender.
Yes.
But once you've surrendered, and once there's a regrant, then those anti-avoidance provisions don't apply.
But how do you surrender and regrant?
Well, the regrant itself results in the surrender. There's no agreement to surrender. It's the regrant that automatically surrenders the previous right. And we say that the anti-avoidance provisions in paragraph 38 have no relevance whatsoever in this context for that very reason, because there is no agreement to surrender.
No, but there is an agreement to regrant, which achieves the surrender.
Yes, it achieves the surrender, but it's not an agreement to surrender that is caught by paragraph 38.
Would it not be caught by paragraph 38?
Well,
Precludes the tenant from making an application or request, or provides for the termination or surrender of the tenancy. And if you're regranting, are you not providing for the surrender?
well, there's no specific agreement to surrender. My lord, there are authorities in relation to this which we can make available, and I apologise that they're not here in your bundles, which deals with this issue in relation to once you've made the grant, then there is nothing to be void. It's because the agreement to surrender, there is none.
So there is case law that, in effect, in the context of a regrant, there is no breach of 38(1). Is that right?
Yes, we don't have it to hand, but we can supply that to your lordships and my lady in relation to that point.
Can I just take you back to the estoppel argument before you finish?
Of course.
Isn't the problem with the estoppel argument that it may work so far as the person you've actually made the agreement with, but the point of having an agreement to confer a code right is that you can then get into paragraph 10 and bind other people. And so far as those other people are concerned, they won't be estopped by anything you've agreed with the person you've deemed to be the occupier, even though they're not. And therefore they'll be able to say that no code right has been conferred, and therefore there's nothing, it can't be extended to bind them under paragraph 10.
Well, my lord, it's either consensual or it isn't. And if it isn't, then you serve a paragraph 20 notice, even though you're in occupation. And serving that paragraph 20 notice is going to have the effect of bringing you within the code.
But then you really are relying on the parties' agreement to confer jurisdiction on the tribunal, which is contrary to basic public law ideas. And the tribunal has to look at the conditions in the code which give it jurisdiction. You're saying the parties can say, well, ignore the code and the conditions there. We will say that that condition has been satisfied. Now, tribunal, do your work against the other persons we want to be bound.
But we would say that's exactly what happens in a consensual situation where you have I call it a greenfield site, because under paragraph 9 you're reaching a consensual agreement under paragraph 9 which gives you code rights.
Surely a greenfield site is the unproblematic case.
Yeah.
That's where the person, the operator, is asking to confer the rights is in occupation. That's not problematic in terms of the jurisdiction of the tribunal. That's the standard case.
But we say that we say by virtue of the estoppel, if I can call it that, we are falling within the definition in paragraph 9, which brings the code into force in the same way that it would be the case in circumstances where you have the simple situation, a greenfield site.
I follow that's what you're saying, but that's what I'm taxing you with. Yeah. That the argument seems to come down to that the parties, although they can't satisfy paragraph 9 on its face, are able to agree between themselves that they will treat paragraph 9 as having been satisfied between themselves, and that agreement between themselves is sufficient to vest the tribunal with jurisdiction for the purposes of a paragraph 20 application.
Well, part 5, it would put part 5 into the mix, because it would be a part 2 agreement, and your lordship's absolutely right. There would then, because of part 5, be an entitlement to seek a code agreement under part 5 once that code agreement had expired. And again, if there was no consent or consensual agreement that had been reached, then the code provides for what happens in that situation. But the flip side of that is that you never go into the code, because if you can't agree, if you're not in occupation, you can't agree consensually to grant code rights, and you can't go to the tribunal and ask the tribunal to impose code rights, and that ultimately is the problem. And this is a solution. It's one of the solutions that we say is available for addressing this issue. It doesn't come without challenging points in the same way that other arguments in relation to the code don't come without challenging points. But we say that given what the code was intended to do, to have a scheme whereby operators have code agreements, the alternative is that there is a whole swathe of agreements that can't get into the code. And without the convoluted processes that would need to be gone through, which we say are absurd and which Parliament could never have intended.
So you say that it can't have been intended that when the parties come before the tribunal in Part 5, that the tribunal has to investigate whether the agreement which the parties are treating as rolling forward Part 2 agreement was in fact originally a Part 2 agreement complying with paragraph 9 or not.
Yes, we say
they just treat it as a Part 2 agreement.
Treat it as a Part 2 agreement, as indeed an agreement that's imposed under Part 5 is to be a Code 2 agreement, and that's provided for in Part 5. In the same way that a Part 4 imposed agreement is to be treated as a Part 2, Paragraph 9 agreement, we say. My Lords, there are further points that have been taken in relation to the objections taken to this line of argument in Mr. Pymont's submissions. It's my proposal that we can deal with those once your Lordships have heard them and by way of reply. We say that this is a simple solution. We don't pretend that it's a solution that doesn't have certain challenges, but it is a solution. It's a solution that's been advanced in paragraph 82. On the estoppel point, and if we take it as being an estoppel point, and my Lord Sales is careful distinction between an estoppel point and a scintilla tempora point, but if we take it as an estoppel point, that in itself it deals with the problem, and it deals with the problem not only in relation to regrants, it also deals with the problem in relation to mid-term rights, which it is accepted, or it has been accepted, that operators should be able to get mid-term rights if they have apparatus in situ and they need further code rights because what they have isn't sufficient to be able to achieve what they have a statutory purpose to achieve under the code. My Lord, my Lady, if I can assist you further, I will seek to do so. Otherwise, we'll take further points in reply.
Thank you very much.
Yes. My Lords, my Lady, I appear for AP Wireless, as the Court's heard, which is the intervener in the Compton Beauchamp appeal, the purpose of the intervention being to argue the points that would have been available to Compton Beauchamp itself, which is not represented on that appeal. And AP Wireless is also the active respondent in the Ashlock and On Tower appeals. As an initial point, and really it's a point of impression, could I address something that Mr. Sietler said this morning about APW's potential interest in this? He mentioned the possibility of ransoms being charged by a landowner of APW's kind, and I think it's appropriate to correct that impression by pointing the Court to what we say in our skeleton argument at page 182. The general heading just before paragraph 138, operators are exposed to ransoms, and then dropping down to paragraph 140, the last sentence of that is, more significantly, if the perceived problem is in part the failure of the code to allow code rights to be conferred when the operator itself is the occupier of the relevant site, it is difficult to see how a ransom situation could develop. The problem in such a case is that there is no one available who can confer the required rights not that a person who can confer such rights has an incentive to hold out for better terms. Now, that is a complete answer to the suggestion that there is any kind of ransom available to the landowner in this situation.
Well, what is your client's interest in these appeals? Why does it matter to your client whether you win or lose?
It has an income stream, and so it is important to know what renewal rights and what the terms of the continuing occupation would be.
Well, in economic terms, there is a battle between two interests to share or to obtain the benefits conferred by the new code or their equivalent. That is what is going on, is it not?
Well, that is absolutely, and that is where I wanted to get to.
Yes, I mean, you're saying it's not a ransom. You're saying that they have no entitlement to the new code. Therefore, we are entitled to the benefits under the old code, as it were.
Yes.
Or we're entitled in some way to share the benefit of the new code with you,
yes,
with the operator, because of our willingness to accede to an arrangement or whatever.
That's right. But these are, all the parties before the court are sophisticated
commercial
players,
yes,
and all trying to work with the code, yes, not to steal a march in any respect, yes, but to work with it. And I felt I ought to start there because Mr. Sietler put that in as a little dig, and I felt I'd been poked by a stick. So I thought I'd better start with a corrective.
Yes.
But even if what you're saying here is, well, if the Court of Appeal is right, then nobody can confer code rights. We can't, so we can't get the money, and you can't get the code rights from us. But what Mr. Sietler was saying is fine, but in fact, because you are really the occupiers of the land, you can confer rights which are not code rights, but in fact entitle Cornerstone to hoist a mast on your land, not pursuant to a code right, but pursuant to a right under an agreement with you.
Yes. Well,
and that you can then charge for that a consideration which is not affected by the no assumption of network effect. I think that was the point that was you were being poked with.
That I have to accept the argument that he's put forward, that I am in a position to grant those rights. And the problem that is created by the code is that only an occupier can make those rights. And if it's, in the case of an operator who is the occupier, that creates a problem. It doesn't make the landlord in any better position.
Well, then I can't understand why your client's bothering to. I mean, it doesn't make any difference to the outcome or who's right or not. But if on your approach, it's just a matter of pure clarity in the law that you would like to know, and it seems a little difficult to accept that justifies spending the money if there's nothing in it financially for your clients.
Well, there will be consequences. Clearly, there are consequences. This is setting the ground rules for what happens next. The narrow point I just wanted to deal with was the rather unpleasant point that we're in this for ransoms, which is not the position, and it's not right that the court should start with that as a sort of outlook on APW's position.
No.
Well, whether or not you describe it as a ransom, if the Court of Appeal is right, it's true that you cannot confer code rights, but you can certainly confer rights to install ECA on your land, but those will not be code rights. I think that's where we are.
Well, where the problem is that there's an operator in occupation, first of all, I have to get rid of the operator in occupation in order to be in a position to grant a new right to somebody else.
Or could you not by contract have ceded to you temporarily occupation of the site in order to bring you in a position to confer paragraph 9 rights?
But I think you don't want to confer paragraph 9 rights or code rights. You just want to confer rights outside the scope of the code on your land.
Yes, but the ECA is there because the occupier is there, with some kind of right, usually. That's the point. I haven't yet got rid of the ECA. Well, can I say this? I can move ahead, because what I want to get on to as swiftly as possible is what we say about the code itself.
Well, I'm sympathy with that, but I do think we need to have some clarity as to what it is in practice that is being fought over. I mean, are you saying that you have a valuable asset, namely that your consent is needed in order to enter into an agreement by which occupation is temporarily ceded to you to confer paragraph 9 right? Or are you saying, as Lady Rose says, that you are in a position to confer non-code rights, nothing else?
I'm not aware that there is any prospect, at least as a general rule, of agreeing anything outside the code. The whole point is to be part of the process which the code creates. Yes. And to be a player within that process.
Yes, well, my understanding was you weren't proposing to enter into arrangements outside the code.
Right.
You were trying to protect your client's position through by discovering what the operation of the code is.
That's right.
Yes.
Yes. Going back to the appeals before the court, all three cases arise from the introduction of the new code on the 28th of December 2017. And in each of them, the facts were that an operator already had ECA on the site before the code came into force, pursuant to agreements originally created under the old code. And it was and is argued by the appellants that the presence of that apparatus creates a problem for the appellant's access to the rights granted by the new code. And they say that is a sufficient problem that requires a solution to be given by this court, as Mr. McGee puts it, to enable the appellants to claim rights under the new code. And the particular solution, as we've heard, is that the court should effectively tune out the presence of the ECA and proceed on the basis that it wasn't there. Under the latest iteration of the argument from Mr. McGee yesterday, we also hear that the court has to tune out the lease itself under which the ECA has got there, and also, apparently for the purposes of the argument, any preliminary steps taken to put the ECA on the site so as to treat the site as one without the presence of the operator whose ECA was there. This is said to be a solution which arises from the new code itself. And we say this approach is fundamentally misconceived. The new code governs new agreements and how they are to be created and protected. It did not and cannot be expected to have contained provisions to deal with situations and agreements which had arisen under the old code. What is more, the way in which the new code is said to enable these historical positions to be dealt with is said to arise from some fine and detailed scrutiny of some of the provisions of the new code, and in contradiction to a clear and express provision, namely paragraph 9. Our submission is that the case against us is an entirely artificial exercise which does not help the appellants and does not lead to the results for which they contend. Their real problem, and that is adopting their language, and if it is the right way to describe it, is that certain types of agreement were clearly and expressly excluded by the transitional provisions from benefiting from the new code. And no argument is put forward as to these transitional provisions being mistaken or as having an effect different from their apparent effect, but a problem that is substantively created by the transitional provisions cannot be resolved by some creative construction of the new code. So, if I may, I would like to start with the new code so as to explore what it does and doesn't do. For this exercise, as the court will have seen, we have the words of the code itself. We have a variety of governmental policy documents which cast light on some of the underlying thinking. And we also have, for fairly limited purposes, the old code, so that we can see where changes were made to the old regime. But as a general approach, one shouldn't start from the appellant's perspective that there is a problem that needs a solution. The new code was clearly intended to apply across the board to a whole host of different sites and relationships and equipment. It was not framed to deal with the specific difficulty in which the appellants find themselves as the result of an operator being in occupation of these three sites. We just have to look at the new code on its own terms to see what it does. So I will go through, I'm afraid that means probably for the third time, and no doubt your Lordship and your Ladyship have been through it endlessly as well. But I'm going to go through it again, and I will endeavour to pick up the particular points that are made against me as we go through the provisions of the code as to the meaning and operation of particular clauses. My general submission is that the particular points are either wrong or wholly irrelevant to the basic proposition, which is that this case is governed by paragraph 9. And if there is an operator in occupation, that means that operator can't apply for new rights.
Well, that's a pretty fundamental problem, isn't it?
It's absolutely the fundamental. My submission is it's absolutely clear from the terms of the new code, and there's no getting away from it. I think Mr. McGee called it the fundamental paragraph. I agree it's the fundamental paragraph. It's what we must identify, and its ambit or its reach is what is at stake. But my submission
is... But doesn't that, if I might just interject there, doesn't that mean that the problem that you're facing isn't one that's just confined to the transitional provisions, because this is a problem going forward?
Yeah. Yes.
If it's a problem at all. You seem to be saying it isn't a problem, as I understand it, but on the face of it, it looks like a problem. Now, you may say, but that's what the code says. The code has created the problem. But I'm not quite sure. You started off your submission saying all these issues are to do with the transitional provision. And on the face of it, I don't quite understand that, because it looks as if there is the problem, insofar as it's a problem, going forward.
Let me just take a broad overview. The point about the new code is that it operates first to confer rights, and then, once rights are conferred, to continue them under the renewal procedure. So once you get into the conferral of rights, you also get into renewal. And when you get to renewal, occupation is not an issue. Just jumping ahead of myself, Part 5 is a procedure which allows a party to a code agreement either to terminate the code agreement in the case of the site provider, or to do something with it, to modify it or terminate it and renew it in the case of either the site provider or the operator. And in that Part 5 process, there's no question of occupation, as a relevant consideration. So under the new code, occupation is relevant at the beginning for the purposes of conferral, but when you are into a valid code agreement, you never have to consider occupation again.
Yeah, but you can't, for example, get an additional code right. You're just stymied there once you've started. You're stuck with. You can keep what you've got, maybe, but you can't enlarge it if you're the occupier as the operator. And it really.
But the problem with the submission that's made against me is that assumes that you could in other situations. The correct solution from the new code is that once you have your original code agreement, you don't have the chance to go back and modify it by, as your lordship puts to me, the possibility of adding a code right. The only availability...
That seems a pretty absurd regime. If you've missed out first time round, well, bad luck.
No, because all it does is if you want a right that's going to arise in the period of the term of the agreement, you must ask for it up front. That means you ask for everything you need right at the beginning. It lasts for as long as it lasts. Part 5 is your ability to seek modified terms, dropping out a right, adding a new right, terminating the whole thing and renewing it. But all of those rights are the corollary of your not having the rights in the meantime during the current agreement.
You can add new rights in Part 5, you say?
Yes, Part 5 specifically accommodates the possibility that after the end of the current agreement,
yes,
you can ask for additional code rights.
But not during the current agreement.
But not during. Mm-hmm. Well, my submission is that's the corollary. So the new code is really intended to operate quite simply, which is you have an agreement that's conferred either consensually or under paragraph 20 at the outset. That requires, because of paragraph 9, the occupier, the original occupier, as it were, initially, to be able to confer those rights. But once the agreement is in place, it's the agreement and the parties to the agreement who get the right to renew.
But isn't the problem with that these agreements, because of the investment that's involved, are likely to be long-term? And it then is a disadvantage to the operator if, as you say, they have at the start of the 10 or 20 years to ask for the kitchen sink just in case they need it over that period, and presumably pay you a consideration which reflects all those rights, even if at the moment they only need actually to use half of the rights. Is that really what was intended?
It's certainly what is now done. In answer to your ladyship's question, yes, it is what is intended, because you have no ability to go back during the currency of the agreement for further rights. So, given that that is the position, the logic is you must get everything you think you're going to need at the beginning. And whether or not that is practically appropriate can be tested by looking at what they've actually done in the cases before the court. It's not, this is slightly different sort of factual situation, but in Compton Beauchamp, they've put in a statutory notice under paragraph 20 on 22, that is 20 subparagraph 2, on the basis, as they would put it, that they're entitled to make that application. And they seek all relevant code rights. The reference I've got is 275. So that's the Compton Beauchamp papers. And relevant provisions start at 290.
What was the page reference for the Compton Beauchamp application?
275, I think.
Yes, I mean, they just quote all the paragraph 3 code rights.
Yes.
Yes.
They just run through, and it's not in exactly the same order, but they just run through the rights that are capable of being granted under paragraph 3. So there's right to install ECA on, under or over land, right to keep it installed, right to inspect and alter and so forth. All of these are accommodated in the statutory notice.
But I mean, that's in respect of the apparatus as defined. I haven't been to the definition, but
yes,
they clearly wanted to put some specific apparatus in. Isn't part of the problem that may be faced that this is a fast-moving area where technology may change, the apparatus may need to be changed?
But don't forget, the minimum right under paragraph 17 to upgrade apparatus is there for the operators to use anyway. So when you have a code agreement, one of the things you get from it is the right to upgrade in the terms that paragraph 17 provides.
Yes, and that's paragraph 7F of this particular application.
I was going to say, and in addition, you are free to agree something even better for yourself. Of course, you'd have to pay for it, but you're free to agree something better than that if that's what you want to do. So technological changes are accommodated right at the outset. This is the statutory notice in Compton Beauchamp. Just for the court's note, there's a similar one in On Tower at 1730 and a similar one in Ashlock at 1206. And they're all of them asking for everything, and they get the right to upgrade and share as a minimum right anyway. So it's not, this isn't something that is done, as it were, right by right. The application is made to get as full a menu of rights as you think might be appropriate to the circumstances.
But if during the course of the fixed term there arises somebody who needs to be bound by the right, who didn't exist at the time that the agreement was imposed, can the operator, despite being an occupier, apply to have that person bound by the right?
Yes. And the reason is that it's only the conferral of rights which is subject to the paragraph 9 provision. So once you have conferred rights, there's always the possibility of making an application against somebody else to be bound by those conferred rights. And you can do that at any time. That's not a problem. Perhaps sometimes you didn't realize that somebody needed to be bound. Perhaps you didn't bother originally, but it becomes relevant to do so. And we'll see, as we go through the new code, some of the references that are relied upon are really, on analysis, references to the possibility of making applications under paragraph 20 to bind people in relation to conferred rights, and not contemplating the conferral of further rights under paragraph 20.
Shall we conduct that exercise after the short adjournment?
Yes, my Lord, yes.
Thank you very much.